cannot be rejected merely because it is improbable. It can only be rejected on the basis of inherent probabilities if it can be said that said to be so probable that it cannot reasonably be true. And as I said, at this stage, the state is calling witnesses. It has already called 4 witnesses. It is now to call witness number 1 on the list of witnesses for the state to testify, in this case. This witness was to commence with adducing testimony on Monday, the 14th of May, 2023. And Advocate Baloyi for the state informed court that on the evening of Sunday, the 14th of May, 2023, witness number 1 got into contact with him and communicated that she is not prepared to testify amidst live, visual, and audio broadcasting of the proceedings. Advocate Baloyi did not call this witness, that is witness number 1, into the witness stand to testify. He made the application in this regard, addressing court from the bar, and he related what this witness told him, advancing reasons behind her reluctance to testify if there shall be visual or audio broadcasting of the proceedings. He advanced reasons for bringing this application in the manner in which he did, stating that the witness only notified him on the previous evening, and it was no longer a good time for him to be contacting anyone at that time of the day. The reasons advanced for the application made by witness number 1 were outlined by Advocate Baloyi, and he stated that firstly, the witness is concerned because she is a public figure, and if the proceedings are beamed live, then she shall be exposed to undue scrutiny and criticism by members of the public. Advocate Baloyi further stated that the second reason advanced by the witness is that the witness is concerned about the fact that when she testifies and there is a live broadcasting of the proceedings, this will pose a threat to her own ability to testify. As I indicated, this case is about a murder which attracted much publication. This murder was reported in both print and visual media. There is a huge public interest in the proceedings in this case. Safety is a concern for all that are involved. The applicant is open to members of the media photographing her along the corridors within this courthouse or anywhere outside the courtroom. Although this witness did not testify, she has in no uncertain terms objected to visual and audio broadcast of her evidence. And that is what Advocate Baloyi communicated to this court. The court has to take the public interest in this case into consideration. It has to consider that the public has the right to access information pertaining to proceedings in this case. And secondly, the court has to consider sensitivities obtaining where the applicant is concerned to have been placed in a situation where she will face the glare and the scrutiny by members of the public. When all is said and done, the court has to ensure that the interests of justice are taken into regard and protected. For a witness to testify in a manner helpful, it is vital that his or her sense of comfort be preserved and protected to the best extent possible under the circumstances from time to time. However, it has been correctly pointed out that the court has to be conscious of the fact that what remains at stake becomes considerations of the interest of justice, and that such should take preference. The rights of witness number one as an individual are pitted against the interest of all the other people that have an interest in this case. So literally we have a situation where the rights of one individual, which are important and which are to be observed, are pitted against the rights of very many other people in the form of people with interest in the case. In the case of Van Breda, the court clearly indicated that technology and the role of broadcasting media to inform the public is part of the right to freedom of the press and the principle on the principle of open justice. The court has to maintain a balance between the observance of the freedom of the press and the right of the individual or even an accused person to a fair trial. Section 173 of the Constitution affords the court inherent powers to protect and regulate its own process and to develop the common law taking into account the interests of justice. The court has to harmonize the right to freedom of expression and the open justice principle on the one hand, and the right to a fair trial on the other. It has to harmonize them with one another in order to arrive at a just and suitable set of circumstances, enabling fair trial and achieving sufficient protection from for the various people or individuals that feature in the case. In the Van Breda case, the court dealt with an application by media to broadcast criminal proceedings. it held that the tension between the rights to freedom of expression and the open justice principle on the one hand, and the right to a fair trial on the other, should as far as possible be harmonized with one another. It held that the court must exercise a proper discretion under Section 173 of the Constitution, in each case by balancing the degree of risk involved in allowing cameras into the courtroom against the degree of risk that a fair trial might not happen. It is notable that and the court made a clear point to the effect that courts ought not to restrict the nature and scope of the broadcast unless prejudice is demonstrable and there is a real risk that such prejudice will occur. The applicant only raised her concerns to Advocate Baloyi and did not testify as already indicated. Through Advocate Baloyi, the applicant expressed concerns that she runs a real risk of suffering prejudice. Our courts have expressed where it comes to situations where the rights and interests of an individual are pitted against the rights of many people, if not the country, and where they are also pitted against considerations of protecting the interests of justice. In the Van Breda case, the court held that mere conjecture or speculation that prejudice might occur ought not to be enough, close quote. It follows, therefore, that an applicant who seeks for the court to restrict the media in the manner the applicant seeks to do in this matter has a burden to show court that such a risk not only exists, but prejudice is most likely to be brought to bear against him or her. The legal representatives of all 5 accused contend that considerations of fair trial shall be sacrificed if the application for an order to restrict the media in the manner the applicant requests is granted. In this case, 4 witnesses have already testified as indicated. 2 of them are police officials who did so without requiring any limitations directed at members of the media. It turned out that the 3rd witness for the state was placed under protection due to fear for his life and apprehension regarding his personal safety. Over the time when he was testifying, an incident took place where members of the media who were doing their job by way of covering this and many other matters in this court or elsewhere sought to have a particular angle in engaging this witness, to which action he did not prove respective. And unfortunately, it resulted in that witness, Mr. Madlala to be specific, having to run for dear safety along the corridors of this courtroom. That incident was followed by an understanding, and it's an understanding which was easily arrived at, where members of the media converged and a report was relayed to the court, and where the court management and members of the media agreed on particular protocols that have to do with the do's and don'ts whilst coverage of these proceedings shall be happening. The legal representatives of all 5 accused contend that the witness number 1 seems to be seeking to be accorded a privilege, if I may use that word, which was not afforded to any other witness that went before her. This position by members of the media proves to be more weightier in the light of the fact that witness number 1 has thus far not gotten into the witness dock in order to unpack or to outline the nature of her apprehension, her fears, and possibilities that she regards as likely to eventuate if her request is not granted. The defense counsels, together with a representative of the media, Mr. Den Rosengarten, strongly oppose the granting of an order sought by witness number 1, and they make the point that this witness has not proven that the court that there is justification for the court to order as she requests. As indicated, there is a vast number of people who have an interest in developments pertaining to this case, who for various reasons are not in a position to make it to the courthouse. Parties who have an interest in proceedings pertaining to this case straddle across far and wide in local, national, and international spaces. Even where some of them are in a position to make it to court, limitations based on the capacity of the courthouse and the courtroom to accommodate everyone who wishes to be in attendance make it impossible that this objective be achieved. It is for that reason that the court, or that efforts ought to be done towards imposing lesser rather than greater restrictions and limitations for those who are interested in following the proceedings in this case but are not able to be in attendance, much as it will be also in consideration of those who are able to attend, but would find that their access to the court is tempered with because of the manner of the implication or of the application of whatever restrictions the court may choose to order. Now, such restrictions are bound to eat away from the credibility of our criminal justice system, which may in turn leave room for keenness on the part of members of the society to resort to taking the law into their hands in the face of adversity brought to bear out of acts of criminality. That in itself will pose further untold harm to the democratic principles in our country, where uprisings and strife already threaten to become the order of the day. It is the argument of the defense in this case that where restrictions are put in place which limit the measure to which access to information or even physical access to the courtroom get undermined, that this may result in a negative image being attached to our criminal justice system. On the other hand, the court has to consider that there is cause to ensure that witnesses who feature in our court proceedings have a form of assurance that, number one, they will live to testify on another day. Number two, they will face the least inconveniences, threats, and fears out of their decision to take steps in assisting courts of law in arriving at the truth around incidents that amount to criminality. That very constitution which the country boasts about and which was born amidst a hype based on promises of fairness and equality before the eyes of the law and the access to justice without any discrimination, that these promises should happen without being tainted by unfortunate incidents that take place because the one or the other witness chose to be of assistance in bringing the court to the truth around incidents that took place, which form part of proceedings before them. Participants in court proceedings, members of society, as well as those who stand accused before courts, stand justified in expecting that fairness and equity shall be part and parcel of judicial decision-making without exception. At the same time, it turns out that ever since the occurrence of the incident in issue in this case, on countless occasions, witness number one herself has consistently participated in social media addressing issues pertaining to this case, and in so doing, she placed her identity, including her face, out in the public, which prompted the very public scrutiny, criticism, analysis, and everything else that goes with public participation in social media, around which she now claims to be harboring apprehension. The defense, together with the legal representative of the media, question why witness number one suddenly and without proper notice seeks to be granted latitude, which is not only different from that which other witnesses in the same case were granted, but which goes overboard, according to them, in not only limiting but also completely undermining the interests of all who seek to follow developments in this trial by watching proceedings. If not that she seeks to blatantly undermine the rights to access to information. The situation is further compounded, as indicated, by the fact that she did not testify and was therefore never subjected to any test regarding her averments pertaining to potential threats to her person, her reputation, and her security if her face and her voice get broadcast over time when she will be testifying. All her concerns were conveyed by Advocate Baloyi from the bar, and it was not possible to interrogate each fact that Mr. Baloyi, Advocate Baloyi, indicated as having been raised by witness number one. It is so that matters pertaining to the safety of witnesses do deserve prompt and adequate attention at all given times. It is not a secret that in our country today, a decision to testify in the one or the other case sometimes gets to be a situation where one is choosing whether or not, or whether to place oneself or not to do so, because we have had incidents reported across all media platforms where witnesses faced consequences because a decision they took to testify in assisting the court to arrive at the truth. Therefore, courts do have a duty to be seen to be going out of their way to protect and preserve the lives and safety of witnesses who testify before them. Failure to do so will prove to be counterproductive in that witnesses will have to decide whether it is worth going through the risk and the dangers that come with testifying before courts. This will result in a malicious dent on the image of our justice system, and it will in turn promote lawlessness and a semblance of the law of the jungle when it comes to responses to criminality. As indicated in the case of State versus Matiti, 2011, in brackets 1, SACR page 40, a Supreme Court of Appeal decision. Our criminal justice system will have failed in accommodating victims of crime and the society at large if no measures are taken to openly demonstrate that the interests of those impacted upon in a negative manner by acts of criminality are protected, and that as much comfort is afforded whilst they go about testifying in various cases. In the case of State versus Manamela and another, in brackets, Director General of Justice intervening, Oregon J and Cameron J said in paragraph 66 in a dissenting judgment, but the particular passage was approved by the majority of the court, and they said the following, and I quote, "The approach to limitation is therefore to determine the proportionality between the limitation of the right, considering the nature and importance of the infringement of right on the one hand, and the purpose, importance, and effect of the infringing provision, taking into account availability of less restrictive means available to achieve that purpose," close quote. Up until now, this court does not know what perils witness number 1 stands threatened with in the event where testimony is broadcasted. The court allowed witness number 3 and 4 to testify with restrictions in place, namely that their faces were not to be shown, especially where it regards witness number 3, Mr. Tumelo Madlala. The defense and the representative of the media do not challenge the position where beaming of the faces of the witnesses is prohibited over time when such witnesses will be testifying up until finalization of this case. Witness number 1's voice and most probably her face are already out in the public due to her past participation in the social media where she addressed issues pertaining to this case. Her explanation is that she needed to protect her integrity consequent to being subjected to public attacks revolving around issues related to this case. Forbidding public broadcasts in which her voice will be exposed to interested parties and the public cannot bring about any benefits, if not consequences, which have thus far not shown. As a result, while the court understands that beaming her face may bring an unintended adverse consequence to bear against her, there is no evidence showing that a public broadcast which exposes her voice can do the same to any unprecedented extent. The court sought to find out from the legal representatives of the accused, given the reality that certain limitations were put in place for purposes of the testimony of witness number 3 and 4. And there was assurance that in the light of how this trial has been unfolding, there is no specific demand that the beaming of the face of witness number 1 be allowed to happen at the time she will be testifying. This court is vested with discretion to allow publication of court proceedings, in particular visual and audio broadcasts. It is vested with the power to control proceedings to ensure a just outcome. In so doing, the court has to be on the lookout for any eventuality or incident that steals away from the focus that these proceedings are about. There has to be a firm understanding that the proceedings in this case are about the murder, the unlawful killing of the late Mr. Sifiso Meyiwa. By extension, this case is about those who held him dear to their lives, be it next of kin, relatives, and people in the sports fraternity, and more specifically with regard to people in the soccer fraternity. This court may allow publication of court proceedings, in particular visual and audio broadcast. It is vested with the power to control these proceedings to ensure a just outcome. However, the court will be remiss if it does that without due consideration of all the dynamics at play and all the possibilities that may arise, specifically out of the manner in which publication of the court proceedings is carried out. As indicated, it is fact that the broader society will retain a deep interest and will want to ensure that justice is done where the open court principle protects their ability to do so. Historically, this meant that justice was done in an open forum where the default position was such that the public is able to come and observe what is taking place. In the Van Breda versus Media 24 case, the court described the interest at stake by broadcasting court proceedings as follows, and I quote, "It is important to emphasize that whilst greater access by the public to the court system by means of televised proceedings would result in 1, demystification of the judicial process, 2, greater informed deliberation and critical assessment of the judiciary based on the public's ability to readily observe judicial proceedings, and 3, increased understanding of and respect for the judiciary based on the public's increased ability to observe the daily working of courts, and 4, improved journalistic standards relative to court reporting resulting from greater coverage of court proceedings and the development of court reporters specializing in judicial matters. And 5thly, high public awareness of deep-seated societal problems. The right to a public hearing does not automatically mean that trials must necessarily be broadcast live in all circumstances. In the case of .com Trading 121 Pty Limited, trading as Live Africa Network News versus King Nomino Ofikie and others, 2000 in brackets for SA 973 C. The court, and by extension the country, had occasion to grapple with openness of proceedings within the criminal justice system. This case arose from a commission of inquiry into match fixing in cricket. The commission chairperson limited the coverage of proceedings only to the press, but banned radio and television broadcasting. The chairperson further denied the application to relax this, even with limitations. In considering the impact of broadcasting of witness, the court stated that the least restrictive means of protecting witnesses had to be preferred. The court further observed that there are differences between audio and visual recordings, which meant that they were more central to freedom of expression, as they were first-hand accounts rather than interpreted materials. In criminal proceedings, the power of a court to limit broadcast of witness testimony stems from a reading of the provisions of sections 152, 154 of the Criminal Procedure Act number 51 of 1977. The default position is that proceedings occur in open court unless some or other reasons exist for it or for that not to occur. The set of circumstances which fall under those which the court may consider as justifying prohibition of the conduct of proceedings in open court include the following. 1, where doing so is required considering the provisions of Section 63, subsection 5 of the Child Justice Act. The court is of a view, or where the court is of a view that it is in the interest of security of the country, good order, good morals, or the administration of justice to have or to place such restrictions in place. Thirdly, it is where it is possible that a witness may come under harm in the event where they testify. Fourthly, where cases involved various sexual offenses, extortion, or attempts to gain an advantage which is not due. Fifthly, where the witness is a minor. And sixthly and lastly, where the court is of the view that the subject matter of the case is inappropriate for those under the age of 18. Considering the circumstances that form the background in this case, and the fact that the applicant did not tender evidence under oath, this court is not in a position to determine how the particular circumstances can or cannot fulfill requirements that come into place out of a consideration of a variety of circumstances as outlined in the paragraph above, which is paragraph 38. In addition, a court exercises a power to regulate its own proceedings in terms of Section 173 of the Constitution when such court determines the manner in which to broadcast proceedings. A presiding judge may exercise a guided discretion on whether to permit the recording of proceedings and to allow open access to them. The witness in this instance complains about security concerns and thus seeks to persuade the court to exercise the power to limit the visual and audio broadcasting of her testimony in particular. Regarding the modality of the exercise of the court's discretion, the balance lies in favor of openness unless there is good reasons for deviating from this position. The court in the Van Breda decision set out the following guidance for the exercise of the court's discretion, and I quote, under paragraph 70. In permitting the televising of court proceedings, this court is doing more than recognizing the appropriate starting point. It will always remain open to a trial court to direct that some or all of the proceedings before it may not be broadcast at all or may only be broadcast in, for example, audio form. It remains for that court in the exercise of its discretion under Section 173 of the Constitution to do so. It shall be for the media to request access from the presiding judge on a case-by-case basis. In that regard, it is undesirable for this court to lay down any rigid rules as to how such requests should be considered. It shall be for the trial court to exercise a proper discretion having regard to the circumstances of each case. It remains the duty of the trial court to examine with care each application. The court should exercise a proper discretion in such cases by balancing the degree of risk involved in allowing the cameras into the courtroom against the degree of risk that a fair trial might not ensue. In acceding to the request, the judge may issue such directions as may be necessary to, firstly, control the conduct of proceedings before court. Secondly, to ensure the decorum of the court and prevent distractions. And thirdly, to ensure that the fair administration of justice in the pending case. The defense averred that witness number 1 participated in a Netflix document covering the incident in this case. However, this averment was not backed by any reliable evidence. It therefore does not fall to be an issue which is deserving of much attendance for purposes of the task that needs to be carried out. Conduct on the part of witness number 1 within social media platforms seems to suggest that she is not camera shy. However, ability to contend with the glare of cameras and dynamics of exposure to public scrutiny do not make for a complete set of considerations to be made. Realities that come with the magnitude of this case, especially this case, the emotions it provokes, and the sense of affinity, keenness, and relatedness of all interested parties to all dynamics obtaining in a case ought to be taken into consideration. Advocate Baloy mentioned that witness number 1 may find it difficult for her to testify if her request is not granted. This was perceived as a threat on her part to desist from tendering evidence for the court to arrive at a just decision. Suffice it to say that appearance before courts for witnesses in court proceedings is largely preceded by the issue of a subpoena directed at such a witness. By virtue of the fact that witness number 1 is to testify on behalf of the state, and considering that she is a lay person, it falls to be incumbent upon the state to appraise her with all applicable legal connotations flowing out of the process. Further than that, like any citizen, witness number 1 has witness number 1 has an equal right to be heard before any court of law. It will not be correct to fault her for having made a request before court in the manner she did. It became wise of her to engage and to communicate her request, and at the same time soliciting the response of this court and the accused persons through their legal representatives regarding the request she made. This was done openly through Mr. Baloyi, and it was done frankly. It suggests that she has placed herself in a space where she is open to a ruling being made regarding the request she made. It is fact that witness number 1 deserves to be treated fairly and equally. Her concerns deserve to be taken into regard, and determination around the request has to be based on considerations of all the factors at play. However, the court finds that where a broadcast of visual images of her testimony may bring unintended adverse consequences to bear upon her, there is no evidence proving that an audio broadcast of her evidence may do the same. Taking all prevailing circumstances into consideration, the court finds that witness number 1 did not advance sufficient reasons to justify an order restricting both visual and audio broadcast of her evidence. At the same time, there is no reason to subject witness number 1 to an atmosphere during the course of her testimony which compares worse as compared to that which prevailed when the last 2 witnesses for the state gave evidence. That is accused witnesses number 3 and 4. And those are Mr. Tumelo Madlala and Mr. Mtokozisi Twala. In the result, the court makes the following order. 1, that live broadcast of the image of the witness, that is witness number 1, will not be permitted. 2, that members of the electronic media are permitted to live broadcast the testimony of witness number 1 by means of an audio. I might just add that the prohibition of images of witness number 1 whilst she testifies shall remain in place until the finalization of this case. Well excused.
As the court pleases, my lord, may I ask that the judgment should be summarized, I don't know how, to the accused, my lord.
Yeah.
If it's possible, I don't know how it can be interpreted or summarized.
You will realize, Advocate Michelle, that when I left here yesterday, you had piled me with stacks of heads that I had to go through. There are typos. I don't know whether the interpreter shall be able to navigate around that. But the typos do not take away the underlying direction and meaning. But if we were to do it live here, the typos might interfere with the speed with which the interpreter does that. I don't know whether it might assist if we adjourn and the interpreter interprets to the accused, what has taken, what has been expressed.
That is in order, my lord.
Can you just give an indication of how long the adjournment will take place?
I'm not in a position to tell. I'm not the one that's going to interpret. So, I mean, all of us know what that will entail, given that we should just determine together how long a break we want to allow.
We will then inform the court when we are ready, my lord.
Yes, except that we will request Mr. Interpreter to do this with the best possible pace in place.
Sorry, my lord, just before court commenced, I spoke to the judge's registrar requesting for a copy. She then informed me that the court had said that the legal counsel will convey to the accused the outcome of the court, my lord. I did make that request way before we commenced. But to do it now, my lord, it's not a possible exercise. If I was supposed to interpret, I was supposed to...
Even with the availability of a copy of the ruling, that will be surprising.
It might take long, my lord. The court took more than an hour now. It might be long. Yes. So I can't give time. It might take long.
Mr. Interpreter, you were not requested to give a sense of time. What Advocate Chololo requires is that the accused become appraised of what was expressed in this ruling.
It's fine, I'll do it.
That is all that is expected to happen.
Thank you, my lord.
Advocate Msololo, is your client satisfied?
Yes, my lord. Thank you, my lord.
As the court pleases, my lord, we thank the court for its indulgence. The interpretation was done, and we apologize for this slight delay. There were other issues that the state had to attend to. My lord, the state calls the next witness. Is witness number 1 on the list is Ms. Zandile Lorraine Khumalo. Lord, we just apologize for the slight delay. The witness is just in a room behind the court. Slight delay.
Yes.
Please take your full names.
Please take your full names.
Zandile Lorraine Khumalo.
Any objection taking the prescribed oath?
I didn't hear. Zandile who?
Lorraine Khumalo.
Any objection taking the prescribed oath? No. Do you swear that the evidence about to give the court is the truth, nothing but the truth? Please raise your right hand and say so with me.
So help me God.
Ms. Kumalo, we are thankful that you are here to testify. I just need to say to you that mic before you, it doesn't augment your volume. It doesn't increase your volume. It is there only for purposes of recording. There will therefore be a need that you speak in such a way that we can hear you. You are free to testify standing or seated or interchangeably. You are free to indicate if you get exhausted and you need a rest, or if there is anything you need to bring to our attention during the course of your testimony.
The court, please, my lord. Ms. Kumalo, judgment has been handed down regarding the request that you conveyed to the state. Has the import of the judgment been explained to you?
Yes, wonke ama rights wami ngifundelwe wona, and ngakhetha ukuthi ngiqhubeke, and in the midst of everything, obviously appealing was one of them.
Okay.
But I chose not to.
All my rights had been written to me, or I was told about, and I decided to proceed. And also appealing was one of them, but I decided not to. Noma ke ukundlulisa ke isinqumo lesesenziwe bekuthi ke ngakwenza lokho kodwa ngathatha isinqumo sokuthi ngingakwenzi.
Ngoba bengifuna ukuthi icala liqhubeke singalokho sichitha isikhathi.
Because I wanted the matter to proceed and not for time to be wasted.
At the same time, nami ngimilana nje ngifuna ukuthi usenza thole justice.
At the same time, as I am standing here, I also want Senzo to get justice.
Thank you, Ms. Kumalo. What is your occupation?
I'm a singer.
Ngiyumculi ngokusebenza.
During the year October 2014, where were you resident?
Bengihlala Spruit View, which is which falls under Maumela'S.
I was residing in Spruit View, which falls under Maumela'S.
Yes, at which address?
13511 Kutlanong Street.
13511 Kutlanong Street.
Is there a name of a section?
Mzamo section.
Mzamo section.
And with whom were you staying at that address?
I stayed with my mother, Ntombi Khumalo.
Angihlala khona ke noma wami uNtombi Khumalo.
The deceased in this matter, Mr. Senzo Meiwa, is he known to you?
Yes.
Yebo, umufi kulecala umuntu engimaziyo noma engangimazi.
Usenzo ngimaze ngoKelly. Uyena wathi mayiqala ezwana naye banobudlelwane naye. And then after ama dates, I think ayemabili mangikhumbula kahle. Wayesethi hey khona umbhuti engihlangane naye kanje kanje.
All right. I got to know him through Kelly. She was the first one who got to know him or who had a relationship with him. And then after about 2 dates, she then informed me that there is this gentleman that I am now seeing.
Naye wayesechaza futhi ukuthi uyena umlisa lo umaze ngomngani wakhe olusha Mthiyane.
She also informed me that she got to know, that is now Kelly, that she got to know this gentleman, referring to the deceased, through her friend Lucia Mthiyane.
Just a minute. Now, can you just explain to the court who's Kelly?
uKelly udadewethu omdala sibabili kuma.
She is my elder sister. We are two. My mother has got 2 children.
Now, can you further explain if you say your sister, Miss Kelly Kumalo, told you that she has met the deceased? What do you mean?
Mangichaza kabanzi kusho ukuthi sebedatile kambadlwana, and then she's interested in him as much as I think naye interested in her.
If I were to explain much deeper, in that they had now dated for now, went on dates on a few occasions, and that she was now interested in him, and same as with him, that he was now interested in her.
Did they have a relationship, a love relationship?
They had a beautiful relationship.
Yebo, babenobuhlekano obuhle.
They loved each other to an extent where babelandelana yonke indawo.
Indlela ke babethandana ngayo, that they were following each other everywhere.
At some point ngiyakhumbula ukuthi uSenzo wakumele ukuthi aye campini.
Just a minute.
Okay.
Do you know as when this love relationship started?
Mangikhumbula kahle noma ngizama ukukhumbula kuphakathi ka 2012 no 2013 kodwa ngingazi I-date exactly.
If I remember well, or I try to remember, between 2012 and 2013, although I won't remember the exact date.
Do you know where the deceased stayed at the time during their relationship?
Bengakaze ngiye kwakhe kodwa ngangizwela ukuthi uhlala eBaklo.
I hadn't yet gone to his place, but I heard that he was staying in Baklu.
Yes, from Baklu. What happened?
And then every now and then ke mabehlangana noKelly bekuthi mhlambe sihlangana ema-restaurant noma endaweni zobumnandi.
Every now and then, if it was so that he was to meet Kelly, would meet at restaurants or were at entertainment places.
At the time of his death, where was the deceased staying?
He was living with Kelly.
Ngesikhathi
Oh,
sorry. Ngesikhathi ke sokushona kwakhe wayehlala kanye noKelly eMalberton.
Do you know if they, or let's put it to this way, do they have any offsprings?
Yes, they have a daughter, Utingo. She is 9 years old now.
Banaye ke umntwana oyindodakazi uThimbo, igama lakhe oneminyaka ewu9 manje.
Now, Ms. Kumalo, is it correct that on the 26th of October, a certain incident occurred which led to you coming to court to testify today?
Yes, kunjalo.
Yes, that is so. kuyiqinisoko ukuthi nge-26 ka-October khona-ke sehlakalo esenzeka esiholele ekutheni ngibe lana namuhla.
Can you, in your own words, tell the court as to what happened? If you can start with the events of the morning.
Sasise Malbertine ekseni ngazo 26 lezo kuyisonto. Kuyimina uKelly umthogo because ulale he slept over.
Okay. On the day of the 26th of October, it was on a Sunday. In the morning, we were in Malbertine, myself, Kelly, and Mtoko, because he had slept over.
No Senzo naye wayekhona.
Senzo was also there. Sinajafini.
Oh, bye bye.
Yes.
Yeah.
Mtoko, is that Mr. Mtokozizi Twala?
Mr. Ntozi Twala, yes.
Mtokozizi Twala.
Masivuka ke.
Now, just before you proceed to say Mtokozizi Twala slept over.
Yes.
Was there a reason why he slept over?
The night before babehlangene no Senzo Stadium, so kwakunetha. So wayeseza ke ezolala ngakuthina.
Okay. The night before, he had met with Senzo at the stadium, and it was raining, so he then came to sleep over at us.
Yes. Yes, you may proceed.
Kwaseke ekseni kwakhona ke ngezwa kuthiwa ethu Senzo no Kelly be discuss ukuthi khona iphathi bekumele baye kuyona iphathi ka Roy Mahamudza, which is one of the players we Orlando Pirates at that time.
In the morning, I then had a discussion between Senzo and Kelly that they were to attend to a party of one of an Orlando Pirates player at the time, or a player that was playing for Orlando Pirates then, Roy Mahamudza.
And then at the same time nathi sasine show because bengisebenza naye ngaleso sikhathi usiswami sasine show Dorothy Nyembe ye Can Do.
At the same time, we also had a show. At the time, I was working with my sister. We had a Can Do show at Dorothy Nyembe.
Just a minute. Yes, and where is this place, Dorothy Nyembe?
It's Soweto.
It's in Soweto.
What type of place is it?
Park kanje.
It's sort of a park.
Yes, you may continue.
Sasasuka ke ekseni sesilungiselela ukuya khona sahamba sisonke emotweni eyodwa.
We then left in the morning preparing to go there, and we all traveled in the same vehicle.
Yes.
Masesifika khona masesifika la sise endaweni yephathi ngoba inhloso kwakuukuthi sizofike sishiya uSenzo endaweni yephathi la ephathini ka Roy Mahamudza bese thina siyaqhubeka semsebenzini.
And then upon arrival at the venue of the party, because the idea was upon arrival at where the party was to be held, we were going to leave Senzo there at the party, and then we proceed to work.
Yes.
Kwasekutholakala ukuthi babesenza amalungiselelo ephathi ngakaqali. Kwase ukuthi ke uSenzo sekumele ukuthi sihambe naye noMthokozisi badlulele nathi siye showini lesasekuyona.
Upon arrival, we then found out that they were still in the preparation phase of the party, and the party hadn't started. So it so happened that we then had to leave with Senzo as well as Mtoko to the show.
Toko is now Mtokozisi 12.
Mthokozisi, yes.
Yes, you may proceed.
And then ke sasesifika eDorothy Nyembe nakhona futhi beku right nje sifike kahle ngesikhathi sase silinda kancane ngoba kwakukhona abasa performer before thina so sizivumele ukuthi singene.
We then arrived at Dorothy Nyembe, and everything was just okay, and we arrived on time. It's so that we had to wait before we could go in because there were those that were performing.
Yes. Did you then carry out a performance there?
Yes, we carried out a performance on that particular day noma futhi sesiqeda sathi ukuhlala kancane.
Yebo ke saperforma ngalelo langa, but after performing we spent a while.
Yes. What time did you leave the venue of the performance, Dorothy Nyembe?
Noma ngeke ngikhumbule isikhathi esi-exact kodwa kwakula ko past 2 to 3.
Although I won't remember the exact time, but it was past 2 to 3.
Yes, you may proceed.
Saseke mase siqala sisingena endleleni sesihamba usenzo mangikhumbula kahle wayiloko efone check ukuthi iphathi ihamba kanjani amalungiselelo ahamba kanjani wayesethola ukuthi akukalungi.
If I remember well, as we were driving, Senzo was on the phone all the time trying to find out as to how were the preparation, how was the party going, and then it found out that how it was, and then I found out that it was not, the preparations were not done yet.
Yes, you may proceed.
And then mase sendleleni kanjalo usenzo wayesecela ukuthi ucela ukuthi ukudlula in one of the houses khona lapha eSoweto lapho nama ngazi but wathi yena mayichaza kwakuhlala umama womdlali ayemazi so befuna ukudlula amshiyela imali.
As then Senzo then made a request to go past a certain house in Soweto. I also don't know the house, but as he explained, it was a player's mother, or a former player or a player's mother who was staying there, and he wanted to go past there and leave money for the lady.
Yes. Did you then stop over at that place?
Yes, we stopped over at that place.
Yebo safika semake kuleyo ndlu leyo.
Yes, and then from there?
And then mase sisuka lapho ke waphinde futhi washo usenza ukuthi ucela ukuthi sidlule kubo kaMthoko. I had never been there before. It was my first time there.
Also, Senzo made another request that he was requesting for us to go past Mtoko's home, and I had never been there, so it was my first time on that day.
Yes.
Kwaseke uMthoko mase sifika khona eSprayt eKatlehong wehla wangena endlini thizeni then mayisephuma waphuma esegqoka itop yokugcina esezongena emotweni futhi.
And when we got there in Spruit or Katlehong, Togo went into a particular house or a certain house, and then when he came out, he came out wearing a top, and then coming into the car.
Yes, we may proceed.
And then sasisuka ke lapho sa driver sangena ku N3.
From there we drove and went onto the N3.
Yes.
Mase sendleleni kanjalo ngangizwa nje senze lokho ekhuluma noTumelo efonini nami uTumelo bengingamazi ngamazi ngalolo suku lolo elokho emcheck ukuthi how far.
As we were traveling, I heard Senzo was talking, and he was talking to Tumelo. At the time, Tumelo was not known to me, and he was trying to find out from him as to how far he was.
Yes, you may proceed.
And then kwase ukuthi emva kwe call lapho uKheli wasetshela usenza ukuthi ucela ukuthi ngcono ukuthi amtshela ukuthi ehle ku N3 sizomthatha ku off ramp yase Spruitview.
Okay, and then after the call, Kelly informed Senzo to tell him to get off at the N3, and then we were going to get him at the Spruitview off ramp.
Who was to be found at the off-ramp?
Tumelo.
Yes, and what is he saying?
And you say it is which off-ramp?
Sorry.
Spruitview off ramp.
Yes, and what is Tumelo's surname?
Madlala.
Madlala.
Yes, you may proceed.
And then nangempela nathi mase siqala sithatha off ramp sisuka ku N3 sesingena ngase Spruitview sahlangana naye as a walker towards where we were waiting for him.
And indeed, when we took that off ramp, we then met him walking towards where we met him.
And just for record purposes, if you say you met him, who are you referring to?
Tumelo Madlala.
Tumelo Madlala. Ngikhuluma ngoTumelo Madlala uma ngisho.
Yes, you may proceed.
And then samthatha ku Tumelo lapho ku N3 sehla sayikhaya.
We then took Tumelo from the N3, and we then went down home.
Yes, and can you just explain to the court why did you head to your home?
We headed home simply because earlier on uKelly spoke to Uma ukuthi okay since iphathi ngasenzeki ngaleso sikhathi Uma siyazi ukuthi njalo ngesonto uhlala ephekile ngaso sonke isikhathi wayesethi uKelly ngcono siyodla lunch ekhaya.
We went down there simply because the party hadn't started at the time, and then Kelly contacted my mother, and then we know that each and every Sunday our mother cooks, and then Kelly then said it would be better for us to go and have lunch there.
More or less, what time did you pick up Mr. Tumelo Madlala at the Spruitview offering?
Mangicabanga kahle if ngisakhumbula bekungo 3 to 4 lapho nje.
If I can remember well, it was 3 before 4 around there.
Yes, you may proceed.
And then sasesifika ke ngaphandle kwasekhaya singakangeni phakathi ejardini sakhumbula ukuthi konje endlini kuzodingeka ama drinks and then sasesithi ngcono siye ezantsi kwa Kwembu's Tavern.
Who's that?
Kwembu.
Kwembu.
Yes.
We then got outside, to the outside of my home, before we could get inside or into the premises. We then thought that, or realized that the drinks would be needed. We then went down to Kwembu's place.
And what type of place is that?
It's a tavern where they just sell drinks, acha, amanqina, and yeah, but basically just beverages.
Laba bethengisa khona ke iphuzo, acha, and referring to amanqina, it's feet. So amanqina is it
Trotters,
which one?
We're inkom.
Inkomo. Oh, they're referring to trotters. Sorry about that because also get amanqina. Okay, so it's trotters.
Yes, you may proceed.
And then masesifika ke ngaphandle kwa Kwembu's Tavern usenzo noKelly ba realize ukuthi abanayo I cash ngoba kwa Kwembu bekungathathwa ilantos iCard.
Okay. Upon arrival at Kwembu's place, both Kelly and Sandra then realized that they didn't have cash, and at the time, because at Kwembu's place they didn't make use of card payments.
Yes, you may proceed.
So nami ke ngaleso sikhathi ngayisesha ngathola ukuthi ngino 400 esikhwameni and then ngathi ngcono ukuthi sisebenzise one.
I then searched myself and then found out that I had 400 rands in my pocket, and then said that it's better to use it.
Yes, you may proceed.
And then ke ngaphakathi kwangena mina nomthokozi Sithwala.
The people who went inside was myself and Mtokozi Sithwala.
Yes.
And then masifika phakathi, that's when we bought Heineken, if I remember correctly, neGuarana.
And then when we went in, if I remember well, that's when we bought Heineken and Guarana.
If you can remember the quantities, you can mention that.
Angikhumbuli kahle quantity, but sawusebenzisa nje wonke u400 kwabushintsho omncane.
I can't remember the quantity, but we used all the 400 and we got a small change back.
Yeah, sorry, just mention all the brands of alcohol that you bought.
Guarana, engikhumbulayo,
Which I can remember is Guarana
ne Heineken.
and Heineken.
Yeah.
Yes, you may proceed.
And then sasasuka lapho ke sabuyela sayikhaya, sangena sapaka, and then sangena endlini.
From there, we then went back home. We drove in, we parked, and we went inside the house.
What time did you get to your house, your parental house?
If I remember correctly, noma ngasekho sure kangakanani, but bekulako 4:30 to 5.
Although I'm not that certain, about 4:30 to 5, or before 5.
Kodwa nje ilanga lalisekhona.
But the sun was still out.
Yes, we may proceed.
And then ilaw ma asamukela khona, and then wasihlalisa phansi waphaka ke.
That's where my mother then made us to sit down, welcomed us, made us to sit down, and then she dished up.
And in which room were you seated?
We were sitting in the dining room.
Sahlezi-ke dining room.
Do you still remember the sitting arrangements there in the dining room?
Yes, I still remember the sitting arrangements.
Ngisakhumbula ukuthi kwakuhlezwi kanjani-ke khona lapho dining room.
We are going to show you a photo number 64. If you are able to explain the sitting arrangement using the photo, you can please do so.
That's photo number?
Photo number 64, my lot of Exhibit B.
Okay, so la kwakuhleluma
Okay, Masud, bamba lapho.
Maybe photo 65, sorry, can you, photo 65? Yes, you
This
can
one?
use both. Let's start with photo 64. It's
Okay.
photo 64 of Exhibit B, my lord.
So la kwakuhleluma
My mother was seated, yeah, my mother was seated here.
Is there a television set in there?
the television set is more to the side.
I-TV ke ingakho uhlangothi lolu.
Yes.
And then kwakuhleli mina la ngoba every now and then ngangilokhu ngidlala nengane la.
I was seated there because every now and then I was playing with a child there.
Excuse me, Lord. Perhaps if she refers to here and there, a descriptor is needed for the FFPLUS to say, like here she means the left portion of the sofa or the middle portion or the other side as the court basis.
Yeah, that's fair enough, my lord. How many couches are there in the dining room?
In the dining room there's 2 couches which are sitting opposite to each other and then an ottoman at the corner.
Kunama couch amabili ke lapha dining room abhekene ekhoneni ukuthi ottoman.
The ottoman. Yeah.
Ottoman ke esekhoneni.
Where will the other couch be?
The other couch will be more to this side, which is opposite this one. Yeah.
Couch ke uzoba ngabo hlangothi ke yena ke
Just
ubhekene nalo.
opposite.
You've just indicated a place that your mother was seated
Yes.
on the edge of
On the
the
edge.
sofa. of the couch, sorry, closer to the television set.
Yes, that's true.
Wayehlezi ke eduze ngaku TV uma.
And then ke mina ngangihleli la phakathi nendawo la.
I was seated here in the middle.
Yes.
And then ke kulo sofa omunye ke lo la opposite.
Yeah, and were you the only two on the
Yes.
couch?
For starters, yes, bekuyimina naye.
Ekuqaleni ke yebo bekuyimina ke naye baba bekuyitho babili abahlezi lapha.
Yes.
Can you point again to the edge where you sat?
This is where I sat.
Or yeah, where your mother sat?
My mother sat at the edge just towards the TV.
Uma wayehlezi lapha ke nanga eduze ne TV.
Yes.
We just want to show you another photo. Photo number 15. So we're just trying to locate the photo with the other couch.
Photo number what?
This is photo number 58 of Exhibit B. So, photo 57 of Exhibit B. If you can just explain the sitting arrangement.
Okay, and then la eqaleni kwakuhleli
And that's photo number?
57 Malot of Exhibit B.
Yes.
It appears on page 60 of the bundle, Malot.
Yes, I found it.
Yeah.
so la eqaleni ngase TV kwakuhleli uTumelo.
Yeah, at the beginning, next to the TV, or close to the TV, Tumelo sat there.
And then eceleni kwakhe kwakuhleli uMthokozi Sithwala.
Next to him was Thokozi Sithwala.
And then eceleni kwakhe kwakuhleli uSenzo.
Next to him was Senzo.
Just a minute.
You say it was Tumelo first,
Yes,
then
it was Tumelo first, and then Mthokozisi right next to him, and then Senzo was right next to Mthokozisi, and then Kelly at the edge.
Bese ba uKelly ke ekugcineni.
So where was Kelly seated?
She was sitting on the ottoman at the edge here.
Mina wayehlezi lapha na ke ekugcineni ke Ottoman.
yes.
Yes, what happened further? You had a meal, then what happened?
And then we had a meal. Kumnandi kuhlekwa. Kuyimina engangilokhu ngikhipha iphuzo edifreezeni.
We had a meal. It was we were having fun. We were laughing, and I'm the one who was taking the drinks out of the fridge.
Yes.
And then
There's a television set there. And do you know if that television set was playing on the day?
yes, ngalolo suku ke ngiyakhumbula ukuthi kwakudlala some English soccer. I'm not really good ngebhola, but ngiyazi ukuthi it was one of those overseas teams.
I know that there was some English soccer. I'm not good when it comes to football, but I know that it was those English teams or overseas teams.
Yes, we may proceed.
And then ke sahlala kumnandi sidla, and then after some time ngingakhumbuli kahle whether uLongwe SMS'd me or phoned me, but there was some form of communication between him and I.
Okay. We had fun, and after we ate, and then after some time there was some form of communication between myself and Longwe. I don't know whether he called me or it was via SMS.
Just a minute. Who's Longwe?
uLongwe was my boyfriend at the time.
Ngangithandana naye ke ngaleso sikhathi uLongwe.
And what is his surname?
Longwe Twala.
Longwe Twala.
Yes, you may proceed.
And then ke wangibuza ukuthi ngikuphi, ngase ngiyamtshela ngathi sisekhaya, sihleli, we were just having lunch, no Senzo and everyone else.
He then wanted to know where I was. I told him that we were home. We were just having lunch together with Senzo and everyone else.
Yes, you may proceed.
And then ke he asked to come, ngathi naye angeke kube inkinga lokho, he can come.
He then wasecela ke ukuthi eze. I then said that won't be a problem. Angeza.
Yes.
And then ngase ngiyahamba ngabuza uma ukuthi ukudla kuzoba enough na. And then uma said, hayi ku right ukudla kukhona kodwa kuzodingeka isopo.
I then went to my mom to go and inquire whether the food would be enough. She then said that the food is okay. The only thing that will be needed is soup.
Yes. Yes, you may proceed.
And then ke after some time uma wayesecela ukuthi uSenzo uKelly ayomthengela isopo la phezulu.
And then after some time, my mother then requested Kelly to go and buy the soup.
Yes.
Yes.
Wayesethi kuSenzo hayi ngizokuphelezela base bephuma bobabili.
Senzo then said, I'll accompany you, and then the two of them went out together.
Yes, you may proceed.
And then ekuthekuse njalo kwangena SMS eqhamuka kuLongwe ethi ungaphandle.
Whilst at that, there was an SMS or an incoming SMS from Longwe saying that he was outside.
Yes.
And then ngase ngene ekamereni ngiyashintsha ngafaka ngathi kufudumele ngoba kwaseqale ngathi kuyabandabanda.
I then went into the bedroom to change just to wear something warm because now the cold was starting. Or it was starting to be cold.
Yes.
Ngase ngiyaphuma ke ngiyangaphandle ngithi ngiyohlangabeza uLongwe we ngathola ukuthi uKelly usayemotweni usawuthatha imali ama coins nakhona because bebengena imali earlier.
Then on my way out to go and meet Longwe, then met Kelly was still on her way to the car to go and fetch money and coins because earlier on they didn't have money.
And then uSenzo went and greeted uLongwe because they were very good friends.
Wasehamba ke uSenzo eyobingelela uLongwe ke ngoba babe abangani.
Just a minute. Yes, and where was Longwe at that stage?
He was in his car.
Wayesemotweni yakhe ke ngaleso sikhathi uLongwe.
Yes, what type of car?
It was a Polo Vivo Ebovo.
Red Polo Vivo.
What color?
Red.
Yes, you may proceed.
And then again nami ngafika ngajoina kulo conversation kaSenzo no Longwe mabesaxoxa nami ngafika ngabingelela isithando sami ngaleso sikhathi.
I also then joined that conversation between Senzo and Longwe, and I also greeted my love or my lover at the time.
Yes.
And then ke ngase ngicela ukuthi uLongwe aphume ke emotweni angene endlini, and then makusenjalo ukheli wabuya emotweni bathathana noSenzo baqhubeka bayothenga esitolo thina sangena endlini.
I then requested Longwe to get out of the car and to go into inside the house, and from there Kelly came back, and then she and Senzo then proceeded to go to the shop.
Yes, you may proceed.
And then ke sangena ke noLongwe endlini wafika bingelela uma wabingelela abakhona wangena wahlala phansi yaqhubeka ke conversation nje.
We then went into the house. Longwe greeted my mother. He greeted the ones that were inside. We sat down, and then the conversation that just proceeded.
And who was inside the house at that stage?
Inside the house was Mthokozi Sithwala and Tumelo Madlala.
Ababephakathi ke ngaleso sikhathi uMthokozi Sithwala kanye noTumelo Madlala.
If you can once again just demonstrate on this photo 57 where Longo was seated.
And then uLongwe mayingena ufile wahlala la ekhoneni towards the fridge and the heater.
When Longwe came in, he sat there at the corner towards the fridge and the heater.
If we can show you photo 64.
So wahlala.
He sat, when upon arrival, he sat here.
Yes, you may proceed.
And then ke after lapho uKheli noSenzo babuya esitolo uKheli wanikeza uma isobho uma wenza isobho waphakela uLongwe wadla.
After that, Kelly and Senzo came back from the shop. Kelly gave my mother the soup, and then my mother then dished up for Longwe, and he ate.
And when the deceased and Kelly came back, where did they sit?
They stood outside. Baqhubeka or at some point uMthokozisi no Tumelo baphumile bayobhema while uLongwe esadla.
Okay. Ubuzileke ukuthi uma bebuya ke umshushi sobuzile ukuthi uMufi noKelly babekuphi wathi babengaphandle. And at some point, Tumelo and Mthokozisi went outside to go and smoke.
Yes.
And then mina ke mangihleli ngaphakathi endlini ngangibezwa nje beyiniza ngaphandle komnyango.
Benzani?
Beyiniza. Okuyiniza, it's when bekhuluma but you can't really hear the conversation.
Okay. And at some time I then heard them just close to the door. They were talking, but we are unable to make out as to what it is they are saying.
Yes. Who are you referring to?
I'm referring to uKheli, uSenzo, uTumelo noMthokozisi.
Kelly, Senzo, Tumelo and Mthokozisi.
Yes, you may proceed.
And then ke kuthe makusenjalo uLongo waqeda ukudla ngathatha iplate ngalubeka ekitchen, and then uKelly wangena watshela uma wathi hayi ke ma usenzo uthi bacela indlela.
Whilst at that, so Longo then finished eating, and then took the plate and went to place it in the kitchen. And then Kelly then came and said, Mother, Senzo would like to go.
My Lord, will this be an appropriate time to take the long adjournment?
We will adjourn for lunch. Ms. Kumalo, we request that at 2 we be back here.